situation before where the license plate is wrong as a result of DMV negligence, and it's associated with a completely different car. So they had to check the VIN numbers and the registration to determine that it actually belonged to Ms. Chinarian's husband. And there was a discussion of they had to look at the VIN inside the car and the engine block, look at the registration, look at all these things to determine what exactly happened here in this very bizarre situation, which they've never encountered before. So unless the court has any further questions. Oh, I'm sorry.
You know, are there any Washington Green factors here that come into play?
Whether or not they were armed or violent or uncooperative?
They were not violent. They were cooperative, right?
No, there's
They
no.
didn't have any weapons.
No, but.
So basically it comes down to the fact of the tinted windows. That's the only other factor here, right?
Well, the car was the car was very large. They didn't know how many people were in it. They couldn't see what they were doing. Nightfall was approaching, and the photographs show that at the time of the stop, it was around sunset, but by the time it was dark, and the officers testified that if one of them fled, they'd have a very hard time recovering that person.
But they didn't look like they were going to flee, did they? They were cooperative.
So I understand, but also the Washington factors wouldn't put a reasonable officer on notice that what they were doing was illegal, given that it was not an exhaustive list, it's such as, and the officers did.
What would you add to the list?
What would I add to the list? I would add that, I would add to the list that you have specific information that you're stopping the proper suspects. And here we had that very type of evidence. They were looking for this almost identical car in this particular area of Sunland, Tahunga.
And so how is that different from Green?
In Green, there was really no investigation. There was a unconfirmed ALPR hit, and the officer there could have run the plate before pulling this person over and subjecting her to a high-risk stop, but never bothered. And the same in Washington. The officers could have done more of an investigation to determine whether or not they were stopping the proper suspects, but just were unreasonably declined to do so. And that's very different than what we did here, which is we did as much investigation as we could, the officers did, before stopping these subjects. Unless the panel has any more questions.
Well, I guess I have one other question. I don't know. Trying to make sense of your argument. It seems that you're saying that a sort of generic level of knowledge about a particular type of criminal activity can be enough to be the sort of take us out of the ordinary circumstances, that you don't need knowledge specific to this situation that you're in. Is that your argument?
The specific knowledge that the officers, I'm sorry.
Because I think it's undisputed that these officers had no specific information about the people in that car. They have specific information about the car. They have no specific information about the people in the car or how dangerous they may or may not be, like you might have in other circumstances where maybe you saw somebody before they got in the car and you saw them do something that would heighten, oh, this person might be violent or uncooperative or whatever. Mm-hmm. We don't have any information specific to the people involved in this situation until we meet them, until they come out of the car and then we see them, right? So that's my point is, you argued sort of these officers get to rely on their training and experience that, you know, vehicle theft is dicey, and interacting with people who are suspected of that is dicey. Probably so. But there's nothing that I can find in this record that gives them information specific to this circumstance. And so I come back to, does the law allow us to have this sort of generic safety concern, or do you need a safety concern specific to this situation? And I read Washington and Green to say we need something specific to this situation. We're not going to create generic, like if you suspect somebody of assault, always go and do this, what I think they called it as a felony stop.
Well, we do have specific information that they're in the particular area where they are looking for, actively searching for this stolen vehicle. So we know that. We have a lot of facts that lead them to believe they have the proper suspects. And also, the policy here at issue doesn't say that the officers always have to do a high-risk stop. It's that they're allowed to, after considering the totality of circumstances, which the officers did consider, and they discussed that before the jury and in their declarations in support of the summary judgment motion.
But the passage I read you from Green
Yes.
requires that there be some indication that the particular suspects pose an immediate threat. So I'm not sure I've heard anything beyond the tinted windows and that they didn't know who else was in the vehicle.
We wouldn't know what type of threat they posed to us until we actually stopped them and cleared the vehicle.
But that's the point that I'm trying to get at, right? Is the extraordinary circumstance test met when officers have a reasonable concern of the possibility of fear? Right? We don't know what we're facing, so it could be dangerous. Versus, do they have to know that something dangerous might happen because of something specific?
I think that they had, in this instance, I think they had enough, they knew enough that they reasonably believed that they were stopping the proper suspects. They had a
Right,
lot.
but this case might be different if they had information about how this car that they thought was the stolen car, how it was stolen, and that it was stolen at gunpoint. And then maybe you would have a different calculus because then they would know something about the suspects they think they're about to encounter. But we don't have anything in the record to know how this car became stolen or that the people who did it are inherently violent. That's my point.
No, I understand that point. The officers are trained and their experience shows them that the people who are car thieves are sophisticated, advanced criminals who use tools and are usually violent. And so the officers relied on that, among other facts, to determine to use high-risk tactics to stop the
Can you
vehicle.
clarify something? When the officer pulled the driver out, could he tell right away that she was unarmed?
No.
She was wearing
Tight.
she was wearing tights and a t-shirt. From the video, it seemed fairly clear that there was no place that she could hide a weapon.
So once she was,
What does the record suggest on that?
the record shows, what the body worn shows is that she came out of the vehicle and she was asked to sit, get on the ground, prone out. And she was wearing tight clothing, but they don't know if she's going to flee.
I thought there was testimony at the trial. Now granted, now we're going back and figuring out the summary judgment standard, that the officer could tell she was unarmed.
I don't think they ever contended that. They did still search her, pat her down afterwards to determine that she didn't have any weapons, but they didn't definitively determine when she stepped out of the car, okay, this woman's unarmed. I don't think there was anything to suggest that on the part of the city.
All right, our questions took you over time. I want to see if my colleagues have any additional questions, Judge Thomas?
Just one, is there any suggestion in the record that the tinting was illegal?
Yes, yeah, the officers did testify that's illegal tint.
So I thought under California law, you could tint your rear windows. Is that right?
Well, this is a very, very dark tint. So I think that it's an illegal, it's darker than what's allowed on the back windows. And I think it was also on the front, not the windshield, but the front.
Okay.
All right, thank you, Aaron.
All right, thank you,
Thank you.
counsel.
The tint was legal. There's nothing in this record that would suggest there's anything illegal about the tint. There's limits on the amount of tinting that can go on a front window and on the front side windows. These are the rear windows.
At 4 inches or something? Is that right?
There's some technical measurement. I'd like to just really address this question of what the law of the circuit is. When this case came to my office, I don't want to talk too personally about it. They can't do this because I read the Green decision when it came out, and I was already long familiar with Washington versus Lambert. And this is a problem because the LAPD, and they're not the only department that does this, tells its officers, you have a possibly stolen car, go to these really maximum high-risk tactics, because there's all sorts of gradations in between this woman had to lay in Foothill Boulevard for 3.5 minutes with her cheek on the sidewalk, spread eagle, that you can do this. And what the essence of the Monell claim, the way I saw it was, is that the officers do this and they're not even trained on these Washington versus Lambert factors. I was on this from the beginning, and I
Press
asked.
counsel's argument that, you know, despite the way the verdict form is phrased, given the jury instructions, the jury necessarily found that there was no constitutional violation?
I think the jury found.
Be kind of a no harm, no foul type of argument.
I think the jury found no constitutional violation because they were told that this is how police officers do it. And they were not told that the Ninth Circuit says it requires a special circumstance, something more than just a stolen car. That's what I think that Green means. That just because there's reasonable suspicion of a stolen car doesn't trigger these extreme tactics during Terry stop investigations while a VIN is being checked. And in terms of their cooperation, Sergeant Cueto saw this car drive by and said, oh, who would think that this car we thought was in a chop shop last night is now driving by? Well, they're different years, but same model, same color, standard. We've seen these 100 times, these suburban limousines. And he followed for 10 minutes. This car made no effort to do anything that was evasive, which one would expect if somebody was being followed by a police car in a stolen car. Then they stopped. They actually stopped before they got pulled over because they thought the car behind them wanted to pass. They immediately got out of the car. They were fully compliant.
We're familiar with the facts, counsel. You're actually over time, so let me see if
Thank
my
you.
colleagues have any additional questions.
Thank you, and thank you for your
Thank you very much,
indulgence.
counsel, for both
Thank you.
sides for your helpful arguments today. The matter is submitted.